You're watching Royal Report 24/7. Before we begin, if you believe the battle over Harry and Meghan's security was settled when they left the UK, you are mistaken. What's unfolding now is a legal and financial earthquake, a ruling so brutal it transforms a royal privilege into a devastating personal liability. This isn't about titles or family drama. It's about a court hammer coming down on the very concept of safety. Subscribe and hit the bell right now, because this judicial decision doesn't just change the rules. It dares the Sussexes to a high-stakes game of chicken with their own security. For years, the question of who protects Prince Harry, Meghan, Archie, and Lilibet on British soil has been a tangled web of emotion, precedent, and bitter legal argument. The Sussex position has been clear. Their inherent risk, due to who Harry is, the son of the king, a former senior working royal, and a veteran of the Afghan War, necessitates state-funded metropolitan police protection when they visit. The Home Office's position, upheld by the Executive Committee for the Protection of Royalty and Public Figures, REVEC, has been equally clear. They're private citizens living abroad, and the finite resources of UK police protection must be reserved for those fulfilling official duties on behalf of the state. It was a stalemate of monumental proportions, until now. Tonight, we are dissecting a legal development so severe it has sent shockwaves from the corridors of Whitehall to the sun-drenched lanes of Montecito. Following a series of confidential hearings and a judicial review fiercely fought by Harry's legal team, the High Court has not merely sided with the Home Office. According to senior legal sources and insiders close to the government's security apparatus, the ruling has taken a staggering, unprecedented further step. The court has effectively hammered shut the door on state-funded security for the Sussexes as private individuals. But more than that, it has laid out a devastating new pathway. If the Sussexes wish to have the level of police protection they desire while in the UK, they must now, and we quote the legal terminology, bear the full commercial cost themselves. In blunt terms, pay from your own pockets. Understand the seismic shift this represents. We must first strip away the emotion and look at the cold mechanics of royal security. This isn't about bodyguards. This is about a multi-million-pound, state-sanctioned operational machine. It involves armed, specially trained metropolitan police officers from the Royalty and Specialist Protection Command, RASP. It involves advanced teams conducting reconnaissance of locations, securing perimeters, managing crowds, and running counter-surveillance. It involves encrypted communications, secure vehicles, and coordination with MI5 and counterterrorism units. This is an apparatus designed to protect heads of state and their immediate heirs. The annual cost for a principal can run into the tens of millions. The court, in its reported ruling, has now assigned a price tag to that apparatus and handed the bill directly to Harry and Meghan. Why has the court taken such a hard-line stance now? Legal analysts we've consulted point to three pillars of the judgment, as described by our sources. First, the principle of precedent. The government successfully argued that creating a special, publicly funded security category for non-working, internationally resident royals would set a dangerous and unaffordable precedent, potentially opening the door for claims from other extended family members. The court allegedly agreed that REVEC's criteria must be rigid to protect both the public purse and the integrity of the protection system. Second, the argument of commercial alternative. Harry's team had argued that no private security could replicate the intelligence gathering and police powers of a state protection detail. The court, however, reportedly pointed to the global private security industry utilized by billionaires, celebrities, and diplomats worldwide. Their position, in essence, was, you have the substantial means to procure elite, global security. The state does not need to subsidize your choice of lifestyle. Third, and most damningly, the issue of control and disclosure. Insiders suggest the judgment highlighted a fundamental conflict. The Sussexes demand a high level of protection, but also an extreme level of privacy over their travel plans and schedules. The state cannot effectively deploy its most sensitive security resources without full transparency and operational control. The court allegedly saw this as an untenable paradox. You cannot have the full machinery of the state while dictating its terms from a private California office. The immediate financial implication is staggering. A single short visit to the UK, with a full RASP level detail for the family, could now cost them, according to security experts we've spoken to, well over £500,000 per week. A longer stay, or one involving multiple publicized events, could see the bills soar into the millions. This transforms every potential trip for a charity event, a court case, a friend's wedding, or even a family visit into a multi-million-pound financial decision. But the real impact is strategic and deeply personal. This ruling, sources close to the couple suggest, is perceived as the ultimate weaponization of security. It creates a direct, punitive financial barrier to their presence in the UK. It means Harry must literally pay a king's ransom to see his home country with his children under the protection he deems safe. For Meghan, who has spoken of feeling unprotected by the institution, it formalizes that abandonment into a pay-per-view model for safety. The response from the Sussex camp is, we are told, one of furious disbelief. They see this not as a ruling on finance, but on fairness and birthright. Their argument will likely pivot to the unique, inescapable threat profile Harry was born into, a threat he did not choose and cannot shed, regardless of his job title. To them, the ruling is an invitation to danger, a chilling economic disincentive to ever return for the palace and the government. However, the ruling is a grim but necessary fortification of a boundary. King Charles, while privately paying by the security impasse with his son, is understood to support the inviolability of Ravek's independent, threat-based decisions. The court's backing allows the institution to say, with the full force of British law, this is not a family matter. This is a state security protocol. It outsources the hard decision from the family to the judiciary. This is no longer a debate. It is a docket, a balance sheet, a line item in the Sussexes' annual budget labeled Cost of Being Harry. The UK court has not just stripped away a privilege. It has installed a turnstile at the border of his old life, with a meter running at a princely rate. The highest court in the land has spoken, and its language is pounds and pence. The fallout from this financial verdict will dictate where, when, and if a prince can ever go home. To follow the next move in this high-stakes financial standoff, will they pay? Will they appeal? Will they stay away? You cannot miss a beat. Subscribe to Royal Report 24/7. Ring the bell and share your verdict below. Is this a just application of the law or a punitive price on heritage? We are here, tracking every legal and personal repercussion. Until the next development, this is Royal Report 24/7, signing off.